All right, welcome. Oh man, live streaming, gotta love it. It is so much fun. Just kidding. So today we are going to talk about the difference between an employee and an independent contractor in the wake of the Dynamex case and AB5 in California. So before we get started, if you're new here, my name is Taylor Darcy with Think Legal. I help entrepreneurs and startups create the business of their dreams. So welcome. If you are new, please comment in the chat where you're from. I would love to hear from you and get to know you, and hopefully see you throughout. I go live every weekday at 11 a.m. To help businesses with their legal needs and to provide support in California. Now, some of the legal advice, or some of the legal, I shouldn't say advice, some of the things we talk about are California specific. Today's topic is one of them, where this really only applies if you're in California, and other times it can apply broadly and generally speaking to each state. But you should always consult an attorney local to your area to make sure that you are well protected in that. If you are local to California, then I'm happy to help you. So, what exactly is the difference between an independent contractor and an employee? Now, a lot of employers use independent contractors to supplement their workforce and or trying to keep the lights on without spending a lot of money on payroll taxes. Well, got some bad news for you. In the wake of the Dynamex case, you're looking at some pretty major issues with misclassifying your employees as independent contractors, and we'll talk about some of the fines and penalties towards the end. But the big issue is when you misclassify an employee as an independent contractor, it can have some pretty expensive consequences. So, but first, let's get into the Dynamex test and AB5. So the number one, it's an ABC test is the way that it's characterized. The number one factor is whether the person is free from the control of the hiring person. And it has to be both in contract and in fact. So they need to be able to come and go and do and maintain independence. You can't tell them what to do or how to do it and maintain that independence. So that's number one. That one's fairly easy to get around, or get through, I should say, not really around, when you're dealing with independent contractors. The next one is a lot more difficult, and this one is the work that an independent contractor performs has to be outside the scope of your work, of what you do. So translated version of that is that, for instance, because I'm an attorney, if I hire a paralegal or a legal assistant, they have to be an employee because that is exactly what I do as an attorney. I do things with law. However, if I hire a plumber, or a plumber hires an electrician, then I don't have to classify them as an employee. I can classify them as an independent contractor. So say I come in and I want to hire a plumber to do some work for me. I don't have to pay payroll taxes on that. I don't have to classify them as an employee. But and you need to make sure that it's like legitimately so. So this has happened a lot too. I worked with hair salons, barbers, other companies where they regularly rely on independent contractors, and because of the Dynamex test and AB5, they now no longer can rely on that, and it's created an issue with the workforce, especially in California, because of it. Now, the last factor is that if they're customarily engaged in an independent established trade, occupation, or business, is the phrasing of it, And this has to do with, for instance, if you're hiring an outside counsel for a law firm, I'm an independent because I'm not necessarily an employee. So there is some positives to this that, for instance, if you don't want to have in-house counsel, you can hire an outside counsel and not have to worry about paying payroll taxes for an employer, because we are in that category of independent trade businesses. Also, the law AB 5 created carve-outs for certain industries, and most of those are professional industries such as doctors, lawyers, graphic design industry, some other that are available to people. And so those industries do not require the Dynamex test. They have a different test to determine their status. But we're not going to talk about that, because for today's video, it's really about the employee versus independent contractor. And for the most part, a lot of people are misclassifying their employees as a way to get around having to worry about payroll taxes. One of the factors of the Dynamex test is that a business can't have an employee and an independent contractor working on the same thing. It has to be separate. They have to be doing different jobs, or they're considered, that's one factor that goes into considering whether they're misclassified or not. One of the very important things about Dynamex and AB 5 is that the intent of the parties no longer matters. If just because you want to be them as an independent contractor, and even if they want to be an independent contractor, you can't classify them as an independent contractor under this test because of that issue. It no longer matters that there's an intent there. And a lot of this has to do with, a couple of things. The legislation and law is meant to protect the worker in a couple of factors, and we'll talk about those in a second. But the idea being that if you're misclassifying an employee as an independent contractor, then the independent contractor gives up certain rights and certain privileges that go with an employee. So it's good for the employer, but it's not as good for the employee. And so the law is meant to protect the employee from being misused, mishandled, and a lot of times what it comes out to is that the misclassified employee is not taxed appropriately. And so it adversely affects them later on, especially in the tax category, because the employer isn't paying their side of the payroll tax. The next factor is the EDD gets involved in one of two ways. If the independent contractor thinks he's an employee and therefore applies for unemployment benefits, then the EDD will investigate. And or if the employer says that they're an independent contractor, a lot of times because of the misclassification, they will investigate to make sure that the person is indeed, in fact, an independent contractor and not an employee. So those are the tests. That's the big, broad overview. One of the factors that you're going to consider is the risk versus reward for misclassifying an employee as an independent contractor. And there are substantial penalties if you misclassify. And I'm just going to read straight from this. If the EDD finds that it is an employee and not an independent contractor, they will assess penalties for back unemployment, state disability, state income tax, and penalties and interest. So it can get very expensive very quickly. And if you misclassify your employee, then they can complain to the Labor Commission, and they can do their own investigation. They can also file a lawsuit against you. And if there's multiple parties that are misclassified, you could be looking at a class action suit. So more than 1, 2, 10, 15 different people that should have been employees that you classified as an independent contractor. And all of a sudden it's getting pretty dang expensive quick. Now, if they find that it was a willful misclassification, the fines are, and I'm just going to read this here, between $5,000 and $15,000 for each violation, and $10,000 to $25,000 if it can be shown that there's a pattern. So one employee misclassification can put you out of business, depending on your business. All because you chose to misclassify them as an independent contractor instead of as an employee because you didn't want to pay payroll taxes. Now, I get the employer is going to question a couple of things. Number one, well, what if I don't get caught? Well, that's a pretty darn big risk, considering that, yes, you might get caught, or you might not get caught, but is it worth that risk? The thousands and thousands of dollars that it can cost you in the long run and potentially bankrupt your business. And for me, I don't think it's worth that risk. I don't think it's the risk is worth that reward. Excuse me. So that's number one. And then the next question is, well, if I can't afford to pay somebody, then why should I, if I can't afford an employment, why should I hire somebody if I can't afford an independent contractor? Well, the answer is you shouldn't. If you can't afford to pay them, the independent contractor, the payroll taxes on them, then you shouldn't hire them. That's the reality. You need to do the work yourself until you can afford to pay the independent contractor, regardless of it, because that risk versus reward just does not is not worth it, in my opinion. Some people try to get around it through using a temp agency, which is not a bad idea, except for, and here's the thing, is it doesn't relieve you of your obligation in a couple of things. If you discriminate wrongfully, or if the temp agency discriminates wrongly, it can still be you can still be sued for that. The other thing is that you still have to comply with wage and hour laws. So you can't leave it up to the temp agency to do the job that you're doing as the actual employer, as opposed to the temp agency. And finally, temp agencies still, even if you do hire them, still open you up to potential sexual harassment and or other harassment type claims. So keep those in mind, that the temp agency solution is not the end-all be-all and or the solution that saves everything. It's a factor, and certainly the courts and or Labor Commission and the EDD will look at those things. But if you have gone off the rails and started doing things yourself, then the reality is that you're still at substantial risk for a possible lawsuit if you breach other factors that go into being an employer. The real important thing here is that the juice in this case is not worth the squeeze. Please classify your employees correctly. It just makes so much more sense, because at the end of the day, staying in business has more value than going out of business because you chose to misclassify your employees, because of the substantial lawsuits that can go with it and just the expenses. So keep those thoughts in mind. If you have any questions or would like to discuss more about your business, please leave them in the comments. I'm happy to help, and I'm here to make sure that you are well taken care of. Again, I go live every weekday between 11 and noon. And as we get more people, I'm going to be adding, we'll be doing Q&As, and I'll be, as people tune in and make sure that they are, I just realized my phone wasn't off. Oops, it happens. Anyway, we'll be going live every day and helping you with your answering questions about law and about running your own business, starting your own business. And so please join me. I'm looking forward to meeting with you and discussing your needs. So, all right, until tomorrow, we'll talk to you later. Don't forget to subscribe and like this video.